Like the intro is a little long. Thank you so much, Daryl. It's so great to hear your voice. It's wonderful also to hear Donnie Savage voice on this afternoon. We are excited to be here with C Joy. We're also broadcasting live on 360 Live, and then we're on Facebook Live, and we also are on YouTube. You are listening to Legal Views with attorney Sheila R. Stuart, and I have with me on today attorney/judge Sam Henderson. And we're going to discuss today some of the new guidelines for expungements, and we're also going to speak in terms of information if you are facing a felony conviction. Now, we're not trying to get anyone off. If you've done a crime, we're not necessarily trying to get you off, but there are a lot of disparities and implications that cause individuals to have to face felony charges when there are mitigating circumstances that they can use other services and other intervention services to assist them without ending up with a felony charge on their record. So what we're going to do today is give you some pertinent information that will assist you. So if you have a friend, a loved one that is in jail, that's facing a felony conviction, this information will prove to be very helpful and of much assistance to that individual. I am located at 231 South Bemiston Avenue. We can be contacted at 314-854-1339. And now I want to introduce my guest, attorney Sam Henderson. He also has served and currently works as a prosecutor for one of the municipalities, as well as a judge in another municipality. So he has seen a lot of individuals that have been charged with felonies. And so we're going to go through some of the more serious felony charges and what some options that maybe you can use if you are faced with a more serious felony. And then if the felony is not as dire, not as serious, you may also have an opportunity to get that felony charge moved down to a misdemeanor and do some type of community-based service to assist you. So, Sam, the mic is yours. Welcome to the show. We are so excited to have you on today. Can you give your information, let individuals know where you are located, and then let's get this information out to these individuals to help them if they are facing felonies or if they are interested in having, knowing the new guidelines, some of the new guidelines for the expungements.
Okay. Well, thank you, attorney Sheila Stuart. I really appreciate you having me to come back and just to share this information. And really what this is really all about is about if someone makes a mistake, they shouldn't be judged for the rest of their life. And we know that because if you have a felony, there's so many things that you just rights that you will give up. You know, as far as you can't own a firearm, you know, there's certain countries, if you travel abroad, you can't enter into it. If you have some immigration status, there's a chance that you can be deported. There's so many other things that a felony conviction can affect individual lives. And so what this is all about, I want to give the information where if someone ever have a family or themselves that are involved and that could be facing a felony conviction, what are some of the things that you can do? I have a law practice at Henderson Law Firm. It's located in the Grove neighborhood. The address is 1027 South Vandervender. That's St. Louis, Missouri, 63110. And the office telephone number is 314-399-8266. And that's 314-399-8266. My name is Sam Henderson.
Okay, great. Thank you. Now, for those that may have problems running into with the law and they're being charged, can you just to start off with the most basic information, what is the distinct difference between a misdemeanor charge and a felony?
Well, most misdemeanor charges, you're looking at mostly fines, and there could be jail time, but no more than a year. Where when you're talking about a felony, that's a year or more, where someone could be facing incarceration. And you can have, like, for instance, a class D felony, that's 7 years and up to $10,000 in fines. So they kind of go with different categories. You have the A, which is more severe. You have the B, C, D, and E. So the difference between a felony and a misdemeanor is that a felony is more of a potential long-term jail time, where misdemeanor can be more of a fine.
Okay, so let's talk about the serious felony charges, the A felony charge. Those charges are least likely to have, you have an opportunity to have those expunged. So if you're facing an A felony charge, and this is your first offense with the law, you want to try to look for some diversions in order to help get that charge down based upon what it is. So let's give our viewers some information as it relates to what a felony charge looks like and how much time that is and what would happen if they are convicted, because you do not want this on your record, because once you get these felony convictions on your record, it is definitely going to infringe upon your opportunities to lease a house, to lease an apartment, to get certain types of jobs, to vote. If you ever want to run for a political office, it's going to hinder all of those opportunities that you can have in the future. So you want to, first of all, try to avoid the criminal lifestyle. That's the first thing. You want to avoid the criminal lifestyle. But if something happened and you are pulled or you get involved in a criminal lifestyle, and this is your first offense, these are some things these are some solutions that you can use with your attorney to assist you. But the first thing we want to say to you is to avoid the criminal lifestyle. And you can avoid the criminal lifestyle by getting a job, going back to school, picking up a trade, contacting some of the community-based organizations so you can learn some skills and use these free services to avoid going into the criminal enterprise, which will likely cost you, it's going to be a hefty price if you are caught, charged, arrested, and then ultimately incarcerated. So, Mr. Henderson, can you share with us the A felony, the type of sentence that carries, and the seriousness of that offense?
Well, with an A felony, as I said, that's the most severe. You can be faced up to 30 years, life, we call lifetime imprisonment, even the death penalty. That's a class A. So you're really looking at those double digits numbers, from 30, 25, like considered life imprisonment and possible death penalty. Then you start looking at more of the B. That's more of like you look at the range from 5 to 15.
That's good, but can you be more specific and share what type of offenses these are? So are we talking murder, capital murder?
Yes.
Yeah. So can you share?
Talking about murder. Yeah. Right. Are you mostly it's going to be mostly violent crimes, talking about murder in the first degree, murder in the second degree, reckless, negligent murder. It can involve kidnapping. So it's more of when you start thinking about less property crimes and more of where there's individuals that are victims and where there's more. So you think about and it could just be just the severity of someone's injury. If someone is involved in someone lost their life, or someone is that they're harmed really severely, you're looking at, it could be an attempted murder. It can be, so you're looking at more of the murders, the more of the kidnapping, the really violent crimes.
Okay, and the reason why this is important is because across the United States, violent crimes are up. The murder rates are up. There are a lot of shootings. There are so many shootings in St. Louis that you cannot keep up with them over the weekend. And for those individuals that have issues with their tempers and they can't control their tempers, and you resort to using a weapon to resolve a conflict or any type of contention you may have with another individual, you need to understand that once that anger subsides and you have entered into a serious and violent act, it is going to carry a heavy, heavy, heavy consequence. And so you do not want to start down that path, because it's difficult enough to find a great job and to make a great living if you don't have anything on your record. It's difficult, period. But if you have criminal convictions for violent crimes, when you have just signed a contract on your own life that is going nowhere.
Yes.
So these are violent crimes.
Yes.
And the young men in the cities across the United States, you want to think about this type of information, because it's easy to get in, but it's more difficult to get out.
Yes, and also to Attorney Stuart, some of you said to be a little bit more specific on what I'm talking about. Mm-hmm. It's any of those crimes where there's an intent to really do someone harm. You're talking about, for instance, a felony A, if someone intentionally inflicts someone with HIV, someone that murdered someone in the first degree, some second degree, where someone did something driving and they know they was drunk and they get in and do harm and kill someone and drunk, when they're intoxicated. If someone's involved in a domestic assault where they're beating up each other and actually there's weapons involved and someone is hurt, is hospitalized or causing the death, or even kidnapping a child, that is what you consider a felony. Felony A. So I just want to give you a little bit more clarity what I'm talking about. More severe violent crimes.
Okay, great. Now, the crime of intentionally inflicting someone with HIV, is that a felony, Class A felony?
Yes, that's a Class A felony, yes.
Okay, so you're hearing this information that these types of actions can result in charges of felonies that carry substantial jail time, or rather prison time. And you want to avoid these types of actions, because in most cases, or in all cases, pretty much, these types of crimes cannot get expunged from your records. Now, can you give us some examples of the Class B and what types of sentencing those generally carry?
Okay, these Class B could be more of, you thinking of more of like some of the sex crimes, sexual assault. They're still severe. If rape, where there's not like a death or anything that's causing, but someone is severely injured. You're talking about if someone. Another example is if it's a serious assault too. If someone is hurt and maybe there wasn't a weapon involved, but they hit someone really hard and they in a coma. So it's more of this. It's like that one step below the most severe type of cases.
And sex crimes are very difficult to expunge, or almost impossible to expunge as well. So you want to also, as much life in you, to avoid the Class B felonies at all costs, because those are the types of crimes that will stay with you for a lifetime. Okay, thank you. Now, can you share further in terms of the next offense?
So like a Class C could be the endangering the welfare of a child. If a parent neglect their child, leave their child by himself and the child is injured, or that you're looking at more of a Class C. And with a Class C, you're really looking at from anywhere from 3 to 10 years that you can be faced inside of the Department of Corrections.
Okay, very good, very good. And if an individual is confronted with these types of charges as a prosecutor, what types of evidence are you looking for that will cause this individual to get incarcerated? And you also are a former police officer, so in most cases the police work with the prosecutor, then the charges are filed, and the prosecutor take that file and prosecute based upon the evidence that the detectives and the police have been able to put together, and then you go forward with your case. In cases like these, where you have, like in St. Louis and some of the other big cities where the crime rate is rising very drastically, what type of evidence would it take for you to move a case forward if it was presented to you? What type of evidence are you looking for?
Well, you're really looking for where is that there's a victim that says this is the person who committed the act. You're looking at if someone made a statement to the police and they admitted to it. You're looking at it if there's witnesses that can connect or any type of DNA evidence. And most of the time, in a lot of the cases, what I do, as a prosecutor, you don't really see a case where there's a single charge. So there can be numerous of charges. There can be someone that is facing it can be different charges. So you're looking at, it can be an A charge, it can be a C charge or possession, which is the D. And you're looking at that these are times, it's just not that you can just be looking at it. It can be, if you look at all of these offenses, like for an example, a D can face up to actually 7 years. So if you have a D felony, then you have an A felony. Now you're looking at from 7, then you're looking at actually it could be 30 to 25 years. And it sometimes is all about how the person's sentenced too, because if it's not concurrent, if it's consecutive, that means that once you get done with the 7 years, you move forward with the next range of punishment. So even though these are different categories on the maximum that you can face, but unfortunately, sometimes when people get in the situation, it's just not one single charge, it's multiple charges in classes. And there's sometimes people are sentenced not just concurrent, which basically mean that if you put all of the charges together, it can be consecutive. So a person can easily facing 50 or something years in prison when they have numerous of charges.
Very good. Now, what are your thoughts about suspended sentences or a suspended imposition of the sentence? How difficult are those to obtain? And share with us some of the circumstances that a prosecutor would accept to be, so if the attorney presents the information and they're seeking to get this suspended sentence, what are you looking for to go along with that negotiation?
Right. So there's two different things. There's a suspended imposition of sentence, which people refer to that as a SIS. That is technically is not a conviction. What it is just the court is not giving you a sentence. A court is just putting you on probation and saying that as long as you complete your probation within this time frame, then once your probation is over, your case is over. But if you have a violation while you're on probation, now you're facing the full max of whatever the offense is. So most of the time, that's not a conviction, a SIS, but a SES, which is a suspended execution of a sentence. That is a conviction because you have the court saying, I'm going to sentence you to 5 years. So because the court sentenced you to 5 years, that is a conviction. And so depending on what the charges are, you may be able to get that expunged. With a SIS, sometimes it may be difficult because sometimes different government agency would challenge it and say, well, you don't really have a conviction, so that's why you cannot get it expunged. So that's why it's very important to consult an attorney to see what's the best way to really help you in that situation.
Would you consider that a part of a diversion opportunity? Those because I worked on a case, and we worked really, really hard for an individual that had committed a multiplicity of wrongdoings and crimes, and he was granted the SIS, but shortly thereafter it was revoked. And I've seen this happen numerous of times with individuals that they get these opportunities and then they lose them as quickly as the courts grant them.
Yes. And that's the thing. It depends on what these conditions are. Sometimes they would say, the court may say that I'm going to do your SIS, but you have a supervised probation. And what the supervised probation means, that whether it's a private agency or whether it's the parole and probation, you have an officer, or you have in some agencies that's going to come in and tell you to do testing. If there's drugs involved, they can do testing. They're monitoring to make sure that you are not associated with anyone with a felony background. They'll check and see if there's any additional charges that's picked up within the time of your probation. So there's different things. The supervised probation is where most people probably get revoked, because you have someone that is monitoring the individual. And that's a lot of times the first offense, you may not be severe. What I mean is that they may not be serving any jail time, but a lot of it is through because of the revocation of the probation, when someone pick up some additional charges, or if someone is found with drugs in their system doing a random test, someone engaged into in another crime. So that's where most of the time where they will revoke the person probation. Now they're back in front of that same judge or in that same court facing the charges that they were on probation with.
Okay, that's interesting. I was thinking about the cost. So if a person is looking for an attorney and they're saying they're being faced with a Class A felony, what would that cost in most circumstances?
Oh, it can be really extremely high depending on what attorney, where you are. A Class A felony, it could be an attorney asking for a retainer of $25,000, because you're looking at these are the most severe charges, and these are the ones that the prosecutor or the state is not going to be willing to really drop unless under some circumstances. So it's like if someone who's injured or someone's hurt, it's likely that those are the cases that's going to move forward and go forward with.
Okay, so you hear this information, serious crime, Class A, you're looking at on the low end, $25,000 retainer. You're also looking at facing 25, 30 years. So is it really worth it? These are the types of crimes that you will normally do the time for them. They are not crimes that are eligible in most cases for expungement. So you're going to be stuck with a trial, or if you have an attorney that enters into a negotiation or a plea deal with the prosecutor, you still will have to do some time. So tell us about a plea deal, on what some of the plea deals would look like.
Okay, well, there's a lot of things. It can be a full range of things. One of the plea deals can be working to try to get the offense reduced. And what I mean by that, if you're facing a Class A, trying to get it reduced down to a C or a different type of charge, or if you're facing a felony, trying to get a felony down to a misdemeanor. Or one other thing is that having someone that's on drugs or accused of a drug offense can be maybe giving them inside of a drug treatment program, or a diversion program, where the person will plead guilty, and then after they plead guilty to the charge, they're being placed on probation. So there's different things that can be done in a plea negotiation, where you're trying to limit the amount of time, and you're also trying to make sure that the person is not, get a really severe sentence, and they have a chance of returning. If they may get jail time, but having a chance to return out to the society and be productive.
Okay. I want to just get your opinion. I know you don't know, but because the person has not been caught or arrested. Mr. Laundrie. He was accused, case, it was in the news.
Yes.
Everybody's talking about this case all over the world.
Yes.
And some people are saying, well, why is this particular case getting so much attention? And there are a lot of missing people out there, but this particular young lady is getting a lot of attention. Miss Petito And the evidence indicated that she was strangled. She was strangled, and it was death by homicide and death by strangulation. So they're looking for this individual, and they have not found this individual. That's why I'm saying you probably don't know, but I just
Yes.
wanted to ask some of the questions anyway. Do you think in a case like his, let's say he's found alive, do you think that he would be charged with something like capital murder for what he has been accused of, and that the evidence already is stacking up against him, and that it's not going to be
Yeah.
something self-defense will not work? She's such a
Right.
small individual. And
Right.
the fact that he has been missing for so long,
Right.
found
Yeah.
alive, and that's going to hurt his chances of getting any type of a deal or second degree murder case. So let's talk about, just for those that wouldn't know, what's the difference between the first degree and the second degree charge. The first degree is the one that was premeditated, but it's more involved in that. So if he's charged, do you think a second degree murder charge would stick for an individual like this potentially, because he has evaded justice?
It could be. It could be second degree. Second degree would be if they were into a fight and the fight, the person could continue to fight and was the most of the aggressor and killed someone. That can be the murder in the second degree. You're thinking about more of in the first degree, someone's planning, someone is setting up, someone is hiring someone, or they're doing it themselves. Second degree is more of the there's a murder. It's severe, but it can be because someone got into a fight and used continue to when the person asks to stop, the person continued to do it, and the person lost their life. So yes, he could face that, and then just different charges too. If he goes into going to another state or different things like that, I think he can be facing a really multiple charges too, and then mostly sometimes it's federal charges. One thing if you did something in the state, but if you cross the state line, then you're talking about involving the federal government as well, because there's a really a manhunt looking for him. Yes.
Mm-hmm. So you think it would be second degree?
It possibly could be second degree, yes, just depending on what the circumstances are, or if he planned this and planned to take her on vacation to do this, then you're looking at first degree. So it's all about what they find out after, after interrogating him, seeing what he's going to say. It's possible it could be first degree or it could be second degree, and especially if someone lost her, she lost her life, unfortunately.
And what about manslaughter?
Manslaughter is more, manslaughter is more when you start thinking about it's reckless, it's negligence. If someone did something that wasn't intentional, but because of they should have known that this was going to be cause serious bodily harm, but they failed to do that. So it just really depends. It depends on the intent. It depends on what the circumstances are. It's manslaughter is more of you didn't mean to do it, but it just based upon the severity of someone lost their life, but it was so reckless. They should have known that this would have occurred.
Okay. Let's talk about briefly DWIs for individuals that they're facing the DWI charge, and what happens in cases like this when the individual is facing their second DWI? How does that look with the prosecution and the prosecutor in terms of reviewing the case, and then this is their second one versus their first one?
Yes, well, the first one is more of it can still be severe because it can cost money. The person have to go through different training, insurance. You'd be placed on probation. You can't, or if someone refused, you can't drive. So it still has that severity. But the more that you have it, it's more of it where you're looking at a chance that there could be an enhancement. So. A lot of the times too, it just depends too if it's at the state level or if it's at the municipal level. What I mean local, if someone get pulled over and inside on local versus whether or not the state picks up. Most of the time, the state can pick up a charge when it's, if they've been pulled over by a state trooper, so that involves the state. Or if they have a history of DWIs, it can be picked up by the state. Whereas the local is maybe less time. Those are more where it will probably be a fine, or you can work to get those reduced to some other charge versus a DWI.
Okay. Well, thank you. You are tuned in to Legal Views with Attorney Sheila R. Stuart, and I have with me on today Attorney Sam Henderson, and we are sharing information to assist those individuals out there that may possibly have a felony offense that they are facing at this time, what they can do, what types of degrees there are in these felonies offenses, and how we can possibly give you some solutions that may help you. Because if you get this felony offense on your record, it can follow you for the rest of your life, and it can prevent you from doing some substantial living, a house, a job, owning a gun, voting, and the list goes on and on. So you want to avoid these charges on your record because they are more difficult to have expunged. Attorney Henderson, can you tell individuals again how they can reach you?
Oh, yes. My office number, the area code is 314-399-8266. That's 314-399-8266.
Great. And for those individuals that are watching, if you wanted to make a comment, that the comments have been disabled. I'll try to get them back on, but for some reason it's not allowing me to allow individuals to make comments on this feed, but I will try to fix it while I'm sitting here. But so Mr. Henderson, let's move on to expungements, and let's just share some information, some of the new policy rules as it relates to expungements. Can you do that for us and share with them? And this is for informational purposes. As you know, depending on the state that you live in, each state will have different guidelines. However, they're very similar. So the guidelines in Missouri are very similar to many of the other state guidelines. But you do want to check your local state guidelines as it relates to expungement. Almost every individual, so many individuals, especially Black men, have felonies on their records. And so that is why I'm doing this again, because many individuals reached out, wanted more information about the expungements, what they can do, and how they can get the assistance that they need to have their records expunged. So, Mr. Henderson, you want to just talk to us for a few minutes regarding the new expungement policies and what individuals can do?
Sure. So what it is like in Missouri before, there was always, if there was a misdemeanor, it took about 3 years from the date of the offense, even before you can even apply to expunge a misdemeanor, or a felony, 7 years. Now the new law that went in August of this year, it kind of caps that and make it limit. Whereas now you can ask for an expungement, request for an expungement after a year for misdemeanor offenses, and 3 years for a felony. For instance, like there was a law where if someone did not have any money, there's just to file the expungement petition can cost close to over $300 some. And the law at that time is you had to pay if you were this expungement. Now the new law gives the court a little bit more an opportunity to waive those fees if someone is unable to pay for that. And then also too includes a lot more. There may be some drug offenses that were not a part of it where you couldn't get expunged. Now there are some drug offenses that you can get expunged based upon, as long as it falls within those criteria. There's is not involving any violent crime, and it's over, that you apply for within that 3 years. So it makes it a little bit, it seems that the trend is that they know that because of these convictions really affects people's lives. You see that they're becoming more lax and more flexible to give people a chance where now, that they can have a second chance in life.
That's very good. I work with young men. I've never done an expungement for a female, which is, I guess, is not that unusual. But have worked with several young men that have needed expungements, and many of those individuals, those charges have kept them from getting jobs. It has kept them from getting promoted on the jobs, and for even applying for certain types of employment opportunities. So if you are in need of an expungement, reach out. If you don't want to reach out to us, reach out to an attorney and begin a consultation to see what you can do in order to have those records removed, to have those charges removed. See what you can do to have the charges removed from your record. Let's talk about the policy, this new policy, Senate Bill 61. Can you tell us about Senate Bill 61?
Yeah, that was what I was just referring to, where it's making it more lax, where it's that 1 year, the 3 years for a felony. Now you waive fees. Now it involves drugs, drug charges, stealing charges. Before there were stealing charges that you couldn't expunge. Now there's stealing charges that you can. Things with, even for instance, trafficking drugs, depending on what you're trafficking, that can fall on expungement. A lot of times people have, before drug offenses, you couldn't get expunged, but now you can. And it just really depends on, now it's more of those, like we said, those class A felonies, those B felonies are the ones that are really where you can't expunge. But even then, you still want to consult with someone to see what can you do. There's different things that, expungement. There's one thing is what they call an expungement. There's something called closed records too, that can help an individual. So there's a lot of things a person can do, and just to keep going over this, and I'm sure a lot of people know this, that's why some people seek out an expungement. Even like if someone is a student, they're applying for financial aid. There's the law where if someone is accused of drugs, of participating in any type of drugs activity, you can be denied financial aid. So it can affect someone that has a job working in, in a hospital or any place where you're going to be, up in the public, where, you can be denied that, or even license, if you apply for a license at the local level, sometimes you can be denied that based upon what the offense is. And what the expungement is just really the court is ordering the agency to expunge, to destroy, to whatever it needs to do to get rid of those records. So what you really want to do when you do an expungement petition, you want to list all of those people who may have those records, those agencies. It can be like if you pull over the highway patrol, you want to say the highway patrol, you want to say the prosecutor office, you want to say the record, the dispository, where they keep the records. You want to even do the prosecutor office, because if you don't include those agency in your expungement petition, then when the court ordered it to be expunged, it may expunge that record from one particular agency, but the other agency still have it. So when they do a check, it can pop up, and then you have to go through this all back over again to try to get your record expunged. So that's why you really want to consult with someone that has done expungement before, that can show you this is what you need to do, so that there's no records. And it could be an arrest record, even if you don't even have a conviction, just your arrest record. You want to get that expunged as well.
Isn't it correct that you have to do it right the first time, because you only get one bite at the apple, and you may not be able to file another petition
right
for so many more years?
Sometimes what you can do an amended petition. For instance, I was in court not too long ago, and there was someone that was representing themselves. They filed a petition for expungement, but they pled guilty to it they used the wrong statute, as if, you know, the one statute where that you use if you're saying that the police had no probable cause to arrest me, they used the statute, they used that particular statute, but they pled guilty to the charge. So that did not apply. But what the court did, the court in that incident said, will you like to amend your petition? It was kind of like, hint, hint, I'm giving you a chance to make it, to correct it. And in that case, the court did that. The court allowed the person to amend their petition. And the person did that, and the court granted it. So it's, you know, you do get one bite at it, but you may be able to amend it. And even if you do file something yourself and there's a mistake, you still want to consult. It's still not too late to hire an attorney that can make those corrections for you.
One of the judges that I was working with basically stated that if the petition is amended, you've amended the petition, but then and the judge rules on it, and you've left off a couple of parties, you didn't realize you had to serve these other parties. You cannot turn around and file it again at that point, because the ruling has already come down and that case is closed. Would you say that's accurate, or are there some other avenues to get around that?
I think there's maybe some avenues to get around that, you know, because the thing is, you're still trying to expunge that offense. Now, there are parts of the rules where it says that you get, you know, you can expunge, you know, one particular like one offense, or so it's the same offense that you're trying to expunge. It's just that you didn't notify all of the parties. And so what you would have to do, you have to notify those parties. You have to, because what you do, the reason why you have to notify those parties, because most of those agencies have an attorney that will represent their interests. So like, for instance, if you filing an expungement and you're looking at the prosecutor office, they're going to have a prosecutor there that's going to represent the state. If you are putting down the highway patrol, they're going to have an attorney that represents the highway patrol. If you're looking for someone that is at the local police, they mostly have their attorney. So what they do, they can challenge. They have a right to challenge your petition. So if you don't give them notice, they never had the opportunity to challenge it. So what that basically means is that even the court granted it to one particular agency, the other agencies can still keep the records because they never received notice. So what a lot of the times I think what you can do, there's a way, you know, you need to consult with an attorney to see if there's a way that you could always request for things to be open. You can, there have been the cases where we list different agencies, but those agencies still had it. So you know, I got a certified copy of the order, sent it to the agencies. When they still did not comply, go back in front of that same court and, you know, let the court know that this is agency have not destroyed the records. You know, so there's different things you can do. And that's why you might want to consult with an attorney that can help you kind of maneuver through some of the complexities of those.
So how would the individual know that the records have not been destroyed? Would it come up again probably when they apply for a job, or how would they get noticed?
So most of the time, unfortunately, that's when they find out, is when they apply for a job and it comes back and they do a record check and comes back. They're like, oh, no, I had that expunged. Well, no, you had it expunged, but you only list the highway patrol. But the police department still has that record. The prosecutor office have that record, and even the court has that record. So, you know, so you have to list all of these agencies, because think of it this way: whatever agency that you want the court to order to destroy that record, you have to put that and identify them. So then what you do, once you get that order, you send that to those agencies, and those agencies have to comply. And because it's a crime if an agencies do not comply with the court order.
Okay, thanks. I want to ask you, get your opinion about drug court, because I think drug court is an excellent diversion program, and I think it's underutilized, especially for young people that have smaller amounts of drugs and so forth. What are your thoughts as it relates to drug court, and whether that is a good solution or remedy that can assist an individual that may face time? And do you think that is underutilized?
I do think it's underutilized because a lot of times crime stems from people use or dependence on drugs. And sometimes people would take, a probation and will not even explore the drug court. So the first thing you want to do, you want to let your attorney know that you're interested in drug court. And each drug court, they have their own different type of policies and procedure. But overall, this is how it really works. Is there is a court that is really designed to help and give a person a second chance that has a dependency on any type of controlled substance. So what you have to do, you have to get screened to see if you are the right candidate. So most of the time you have to get an order from the court requiring the person to be screened. And that's just a matter of an attorney requesting for that order. And once you get that order, then they have someone that actually screen you, ask you questions, find out all about your history and get all this information. And then they go and they consult with the drug court. And then they all decide whether or not, is this is an individual that can benefit from the drug court. And one of the things that you have to do, a lot of people don't realize, you have to plead guilty while you're in the drug court, because the reason why they want you to plead guilty is, let's say you go through drug court and you fail after giving chances. Now they don't want you to have to start all back over and clog the court. So now there's a possibility you can be facing time. So that's what they're going to require you to plead guilty. And then let's just say that if you go through the drug court, which it can be very demanding, because they really have expectation, they give you a chance. And each courts are different. They may be, if someone have a test that comes back positive, they may lock you up for a few days and then let you out. And sometimes they may not lock you up. It just depends on what the program is and so they have counseling, they have self groups. It may take over a span of a year to complete. And but if you do complete it, at the end of the day, what the state would do would drop the charges. And once they drop the charges against you, you have no record. So that's a benefit for people, giving a person a chance that is dependent on drugs and committed a crime while they're on there. And I think it is underutilized. I think that a lot of times people would take a probation. They would, take a conviction and say, hey, as long as I don't have to do jail time, and then let's get it over with, but not exploring the drug courts, because that can be a really great remedy for someone trying to get their life back in order.
I agree. And I think that prosecutors across the nation, that's one remedy that they can all use, are the drug courts and the different diversion programs.
Yes. And even one thing is to do too. Let's just say, unfortunately, if you go through the Department of Corrections, we're talking about how to stop you from getting that felony convictions. But let's just say that you pled guilty, they sentence you to 5 years. There's still programs called long-term treatment, which is if the person go in, they can go into the Department of Correction, actually go to prison, but they go through the long-term treatment program. And if they successfully complete courses and do what they need to do in the long-term treatment, they would be released from the Department of Correction, given a second chance. So even if you may have that conviction, but you may not be locked up for 5 years, you can be, given a chance where you do a long-term treatment. And they're all different. I'm talking about the Missouri long-term treatment, but different other states may have the thing too. You have to check your rules. There may be, you want to explore doing long-term treatment while you actually, if you do have to go to prison, that can keep you from not being there for 5 years. You can be released probably within, a year or so. So still, even if you go to the Department of Corrections, that's still, you might want to explore that as an option. And it all goes with your plea, like you're saying, getting an attorney that can look out for your best interests.
Because yes, I think so many individuals have very long-term sentences for crimes where there are some mental health issues involved and there are some drug addiction issues involved. And I think that the judicial system has to not looking the other way at individuals who have committed heinous crimes. We're not suggesting that if you commit a heinous crime, you should just have the opportunity to walk away. But those individuals that have mitigating circumstances, such as mental illness and drug addiction, I do believe strongly that some other programs should assist that individual to lower their sentencing and get them the assistance that they need. And it appears that in the United States, many of the prosecutorial programs or the prosecutorial sentencings, it just don't take those things into consideration for individuals. What are your thoughts on that as a prosecutor?
Yes. Well, no, seriously, what I do is a lot of the things I look at, it really goes to what the offense is, what's the circumstances. And it comes down to, if this is the first offense versus a second offense, is this is a person who made a mistake, or is this a career, a person made a career out of doing crimes. So it looks to be, and it's not all the time, but the first offense, most of the time, is where you can really, depends on what the offense is, you can really have a better, more flexibility, or people are willing to give you a chance. The state is willing to, to give you probation versus jail time. But when you start getting different, stacking on more offenses and more things, then always become more complex, because they say, okay, you had your chance, now you're showing that you're, this is who you are, and there's victims we have to protect. So I think people needs to explore it, and you need someone to really that's going to advocate for you. Because, instance, there's so many things that they're developing and trying on. There's some courts that have veteran courts where people who's in the military who had different, coming from being in the military, having different mental illness and diagnosis. Now there's actually courts for veterans they're trying to keep veterans out of prison and trying to give them a chance based upon knowing what they saw, what he saw overseas, and how that impact them. They're trying to give them treatment. So there's more course of being more flexible and giving them options. But you just got to have someone who's going to really advocate for you. And the first thing I tell clients, you have to be your own advocate. That's the first one. Then you get someone who they can work along with you, that can advocate for you as well. And that's why we're here. We're here to help you and do what we need to do. If you are in a situation where you got a felony conviction, where you facing it, that don't necessarily mean that you would get it. And that's why we're here to help.
Excellent. You are listening to Legal Views with Attorney Sheila Stuart. We have with us on today Attorney Sam Henderson, Judge Attorney Henderson, Prosecutor Attorney Henderson, and we are hoping that we can give you some valuable information that would assist you if you are facing a felony conviction or if you are in need of expungement of records, okay? Because there have been some policy changes and you may be a candidate for an expungement. And hopefully we have shared some information with you on this evening that will allow you to get the services that you need. So as we get ready to wrap up, if you were to give an individual some information to assist them, what would you share with them this evening to assist that individual that's facing a felony and an individual that's in need of an expungement?
Someone who's facing a felony, the first thing you want to do, I recommend this, and I'm a prosecutor, I'm a former police officer, but the first thing you can do is, if you are accused of a crime, you revoke your right not to speak, because a lot of the times the issue comes down to what you put out, you can't take back, and someone who may be representing you. Now you're stuck with a statement that you made, and there could have been something that someone could have been in defense. So the first thing you want to do is, just like I said, you be your own advocate. So that means that you don't make a statement unless you have legal representation there with you. Then the second thing you want to do, you want to explore. You want to be upfront with your attorney. You want to tell your attorney everything in no surprise, because then he or she can look after you and advocate for you. If you were taking drugs, so now when this offense occurred, now we can be looking at drug court. If you have a history, of being dependent on drugs, we can explore different things. And the more think about it, the first offense is more where it's more flexible. When you start getting to the second, third, that's more of a problem. And there's a chance too that your sentence can be enhanced. A lot of the times it can be if you have a B felony, but if you are a prior and persistent offender, which basically means you have 2 or more convictions, they can advance that up to the next level. So you have to be very careful on what you do in life and make choices like what we said before. So then when the next thing is when you made a mistake, if you have improved your life and you want to go on and make change your life, start looking at an expungement and do the research and hire somebody that specializes in that. And that's why we're here and we're offering the service for that.
Okay, excellent. Thank you so much. Give our listeners how they can reach you.
Okay, my firm, Henderson Law Firm, is located in the Grove neighborhood in the city of St. Louis. That's 1027 South Vandervender on the 6th floor, St. Louis, Missouri. Zip code is 63110. My office number is 314-399-8266. That's 314-399-8266. Sam Henderson.
Okay, do you also handle federal appeals and federal cases?
I do handle felony, not federal appeals unless it's civil, but not having felony criminal appeals. I've had some cases where we have actually challenged it, habeas corpus petitions. What that basically means is at the state level, we're saying that because they were denied their constitutional rights, now at the federal level, we're asking for relief. So I have to represent individual in those cases. It just really depends on coming to the office, call my office. We'll sit down and talk and see if there's something I can help you with, or if there's someone that we can refer you to.
Okay, awesome. Well, thank you. You have been listening to Legal Views with Attorney Sheila R. Stuart with my guest today, Attorney Sam Henderson. We hope that we have provided you with some information that will point you in the right direction and assist you as you travel this scary road. If you're facing a felony and you need an expungement, it can be a very intimidating process, a very scary process. And if you need any assistance, feel free to reach out to myself at 314-854-1339 or Attorney Sam Henderson at
314-399-8266.
Okay, awesome. Thank you very much. And now you are in the hands of Daryl Breath, all the way in Boston, Massachusetts. Thank you so much for tuning in with us on this evening. Mr. Henderson, do not leave the studio. Thank you.
I'm here.
Good night.
Thank you so much. Goodbye.
Bye-bye.